We have reached page 18, and I am reading from item C, which deals with as follows: breaches by the EU and its member states of the general rules of international law, which require the EU and its member states to respond to violations of international law committed by Israel. Israel's violations of international law are frequently violations of peremptory norms of international law, jus cogens, targeted killings that violate the right to life, deprivation of the liberty of Palestinians in conditions that violate the prohibition of torture, violation of the right of people to self-determination, living conditions imposed on a people that constitute a type of apartheid. The peremptory character of these norms is attributable to the fact that they cannot be derogated from, or that they have been explicitly assimilated to, peremptory norms by the most authoritative scholarly opinion, namely that of the International Law Commission, the ILC, on the prohibition of apartheid and respect for the right of peoples to self-determination. Cited here in the document are the articles of the International Convention. When they witness the violation of such norms, even at a considerable distance, states and international organizations cannot remain passive and indifferent. In Article 41 of the draft Articles on State Responsibility, the ILC adopted a provision to the effect that states shall cooperate to bring to an end, through lawful means, any serious breach within the meaning of Article 40, the breach of a peremptory norm of international law. In its commentary, the ILC makes it clear that, quote, the obligation to cooperate applies to states whether or not they are individually affected by the serious breach. What is called for in the face of serious breaches is a joint and coordinated effort by all states to counteract the effects of these breaches. The EU and its member states are therefore under an obligation to react in application of international law to prevent violations of peremptory norms of international law and to counteract their consequences. By failing to take appropriate action to that end, the EU and its member states are breaching an elementary obligation of due diligence pertaining to respect for the most fundamental rules of international law. The RTP considers that this obligation to react implies, in accordance with the rules of good faith and due diligence, the obligation to ensure that the reaction against violations of peremptory norms of international law complies with the principle of reasonable effectiveness. To that end, the EU and its member states must use all available legal channels to ensure that Israel respects international law. It therefore calls for a response that goes beyond mere declarations condemning the breaches of international law committed by Israel. Of course, the RTP takes note of these declarations, but they are no more than a first step when it comes to meeting the international obligations of the EU and its member states. They are not fully performing the duty of reaction imposed by the rules of international law. Lastly, the RTP wishes to emphasize that the obligation to react against violations of peremptory norms of international law must be subject to a rule of non-discrimination and of unacceptability of double standards. The RTP is perfectly well aware that states have not codified a rule of equidistance in respect of the obligation to react, but it holds that such a rule is inferable as a matter of course from the principles of good faith and reasonable interpretation of international law. Refusing to accept it will inevitably lead to a result which is manifestly absurd or unreasonable and which is ruled out by treaty law. In these circumstances, the RTP considers that it is unacceptable and contrary to the aforementioned juridical logic for the EU to suspend its relations de facto with Palestine when Hamas was elected in Gaza, and to maintain them with a state that violates international law on a far greater scale than Hamas. And now we come to item D, which deals with, as follows, failure by the EU and its member states to refrain from contributing to the violations of international law committed by Israel. The RTP notes that reports by experts have brought to light passive and active forms of assistance by the EU and its member states for violations of international law by Israel. Attention has been drawn, for instance, to the following: exports of weapons and components of weapons by EU states to Israel, some of which were used during the conflict in Gaza, the end of December 2008 and January 2009. Next, the exports of produce from settlements in occupied territories to the EU. Next, the participation by the settlements in European research programs. Next, the failure of the EU to complain about the destruction by Israel of infrastructure in Gaza during Cast Lead. Next, the failure of the EU to demand Israeli compliance with clauses concerning respect for human rights contained in the various association agreements concluded by the EU with Israel. Next, the decision by the EU to upgrade its relations with Israel under the Euro-Mediterranean Partnership Agreement. And finally, tolerance by the EU and its member states of certain economic relations between European companies and Israel involving commercial projects in the occupied territories, such as, for example, the management of the Toblan landfill site in the Jordan Valley, and further construction, as an example, of the tram line in East Jerusalem. For these acts to qualify as unlawful assistance or aid to Israel, two conditions must be met. The state providing assistance must do so with the intention of facilitating the wrongful act attributable, in this case, to Israel, and it must do so knowingly. Article 16 of the ILC draft articles on state responsibility reads as follows, and quote, "A state which aids or assists another state in the commission of an internationally wrongful act by the latter is internationally responsible for doing so if A, that state does so with knowledge of the circumstances of the internationally wrongful act,